Jazz hands. Ah. Jazz hands. Ah. Jazz hands. Ah. Jazz hands. Ah. Jazz hands.
like everything.
Good morning. Good morning. Got things all messed up here. Jazz hands again. Ladies and gentlemen, welcome to the Court Gallery Live. Welcome to the weekend review. We have some interesting stuff in store for you this morning. Not all of it was absolutely from this past week, but all of it is absolutely interesting. We're going to start our day off with Simpson, which is a little different from normal. We have a special session with Simpson. And then we have a little something I like to call Simpson's Valentine to Judge Conlon. So we'll have a little bit of a mix where we'll see some videos that we've seen previously with Judge Simpson. We'll see at least one that we've seen previously. We'll get an update to that, and then we'll see the defendant move on over to Judge Conlon's court for disposition, for further disposition. I'll just put it that way. Next, after that, we're going to move over to a secret court case. I'm not going to tell you much about it. I'm just going to tell you it's before Judge Garcia. Then we're going to go over to Judge Garcia, who's in Texas. So we're going to start in Michigan. We're going to go to an unknown, undisclosed territory. Then we're going to go to Judge Garcia. Then we're going to end up in North Dakota with Judge Thornton for the last part of our show. Ladies and gentlemen, we're getting it started right now. Thank you for hanging out. Chat's going to be amazing.
This is a special session of the Washington County Trial Court regarding the swearing in of Ms. Alexis Zerps, the Honorable J. Cedric Simpson presiding. You may be seated.
And in the matter of Zerps, I believe, counsel?
Yes.
We do have Mr. Kerpaul, I do believe it is. We do have a motion. Yeah, you got to come up there, counsel. Come on. Got to figure out how to do all this stuff.
All right. Good afternoon, Your Honor. Ian Kerpaul, P72110, on behalf of Ms. Alexis Zerps. This is my motion to admit Ms. Zerps into the practice of law in the state of Michigan. In support of this motion, Your Honor, I've known Ms. Zerps since she was about 13 years old. When she started to attend a youth group I helped run in East Point, Michigan at St. Veronica Church. Through that time, she has shown herself to be a high moral character, leadership abilities, and we called her a go-getter, which she certainly was. And when I saw those qualities in Ms. Zerps, when she was still an undergrad going to Macomb Community College, I asked her if she wanted to start working at my law office, initially helping out with making copies and whatnot. And then I asked her if she wanted to learn more about the profession and all that. She said, absolutely. And Your Honor, she first started when she was 14 pulling weeds at my office. And then she eventually started drafting appellate briefs all by herself. Ms. Zerps is a highly intelligent, very smart, hardworking. She was my right arm, left arm at the office. I'm completely lost without her. And I'm going crazy. She's outstanding, and she's dedicated to criminal defense. She's going to make an outstanding criminal defense lawyer. Any client should be blessed to have her as an attorney. So, Your Honor, it is my honor and privilege that I ask this court to admit her into the practice of law state of Michigan. She's going to make an outstanding lawyer and zealous advocate for her clients. Thank you, Judge.
Thank you, Mr. Kerpaul.
Yes.
Well, I'll just take a matter of personal privilege. Ms. Zerps has been before me for what, 4 years? What was it? How long were you before me?
A couple months.
Oh, okay. It seemed like 4 years. Anyway, and I would agree with everything that you've said, because the way that she practices, I mean, even starting out the first couple of days, I was rather amazed at the maturity, which I don't always see, an understanding of sort of what needed to be done, a careful attention to detail in terms of the client, which I think is also extremely important for any attorney to have, particularly defense attorneys, particularly those representing indigent defense. My understanding also, Ms. Zerps, is you were recently married. Where's your husband?
Right here.
Okay. My apologies and condolences. Then you'll understand what I'm saying when I say this, okay? She comes in, and most of the time, new younger attorneys, they come in and they're kind of shy. They're kind of, the judge rules. They just kind of take it. And they just say, well, the judge must be right, whatever. So I know you've gotten this before, where all of a sudden you made a decision. She kind of looks at you and just goes, really? After all the information you had, that's what you did? So she does that. And then the other thing that she will do, which I'm still not sure how to handle this, is I'll make a decision. She like looks down like almost like I did the wrong thing. And then just very quietly says, thank you. And I know she doesn't mean it. I completely understand that. But she does it all very respectfully and with such grace. And I will say it has been, for me, seeing a lot of attorneys come through, an absolute pleasure having you. And I think I expressed this to you, having you practice before me, and just sort of in that brief period of time, watching you, even in that time, mature and grow and gain an understanding of law. There is not a doubt in my mind, and I would join in the comments of counsel, that you're going to be an outstanding lawyer, and that people will be truly blessed to have you represent them. And I mean that from the bottom of my heart. And I am also honored that when you asked me to perform this ceremony for you, I get to do not necessarily a lot of them, but some of them are a little bit more special than others. This is one of those, because there's something very special about you. And so never forget that as you go through this journey. Okay. Are you ready to take the longest oath known to mankind?
Yes, Your Honor.
All right. So who's here with you? Because you've got your husband.
Yes, and then next to him is my sister-in-law, who's married to my brother, sitting next to her.
Okay.
And then over here is my mother-in-law, my mother and father.
Mom and dad.
I expect you to know all the attorneys in the
What?
room because they've probably been in front of you.
No. Okay, I know them, don't like them, but whatever. All right. Well, that's fantastic. And Dad, let me just also say this. I can't remember which shift Alexis told me that you worked. And when we were trying to set this up, the one thing I said, well, what time do you want to do it? Whatever. And the one thing that she kept making sure of is she wanted you here. And she said that it has to be at a particular time so that you would have time to do what you needed to do and then get here. So your little girl wanted you here. And so that is something special. So if what we have is your husband and your mother and father, they would also come up, because what I also realized about this journey is you don't get here alone. That way they can stand next to you. Doesn't that feel better? All right. Ready?
Yes.
Thank you. All right. Alexis, will you please raise your right hand? Repeat after me. I, Alexis
I, Alexis
Zerbst, do solemnly swear or affirm
do solemnly swear
or affirm
or affirm
that I will support the Constitution of the United States
I will support the Constitution of the United States
and the Constitution of the State of Michigan.
and the Constitution of the State of Michigan.
I will maintain the respect due courts
I will maintain the respect due to courts
of justice and judicial officers.
of justice and judicial officers.
I will not counsel or maintain any suit
I will not counsel or maintain any suit
or proceeding
or proceeding
which shall appear to me to be unjust,
which shall appear to me to be unjust,
nor any defense
nor any defense,
as such as I believe
except such as I believe
to be honestly debatable
to be honestly debatable
under the law of the land.
under the law of the land.
I will employ for the purpose of maintaining
I will employ for the purpose of maintaining
the causes confided to me,
the causes confided to me,
such means only as are consistent
such means only as are consistent
with truth and honor.
with truth and honor.
I will never seek to mislead
I will never seek to mislead
the judge or jury
the judge or jury
by any artifice or false statement of fact or law.
by any artifice or false statement of fact or law.
I will maintain the confidence
I will maintain the confidence
and preserve inviolate
and preserve inviolate
the secrets of my client,
the secrets of my client,
and will accept no compensation
and will accept no compensation
in connection with my client's business,
in connection with my client's business,
except with my client's knowledge and approval.
except with my client's knowledge and approval.
I will abstain from all offensive personality
I will abstain from all offensive personality
and will advance no fact prejudicial
and will advance no fact prejudicial
to the honor or reputation
to the honor or reputation
of a party or witness,
of a party or witness,
unless required
unless required
by the justice of the cause with which I am charged.
by the justice of the cause with which I am charged.
I will never reject
I will never reject
from any consideration.
from any
Go ahead.
consideration
Personal to myself,
personal to myself,
the cause of the defenseless or oppressed,
the cause of the defenseless or oppressed,
or delay anyone's cause
or delay anyone's cause
for lucre or malice.
for lucre or malice.
I will in all other respects
I will in all other respects
conduct myself personally and professionally
conduct myself personally and professionally
in conformity with the high standards
in conformity with the high standards
of conduct imposed
of conduct imposed
on members of the bar
on members of the bar
as conditions for the privilege
as conditions for the privilege
to practice law in this state.
to practice law in this state.
So help me God.
So help me God.
Congratulations, Ms. Serbs.
Thank you, Your Honor.
Mrs. Herbst, this is your day. Is there, after you get finished hugging everybody, is there anything you'd like to say?
Oh, geez, I didn't expect to be put on this spot like this. I would just like to thank everybody at the Public Defender's Office who have helped me get to this point and has been there to help me along the way, to learn and to practice up to this point, especially Lauren and Natalie. They were there by my side for the first couple months when I was nervous and asking them tons and tons of questions. So I really appreciate them for that. And obviously I appreciate everybody who came out to see this. It's been a long time coming, I feel like, so glad that it's here. And it was a long 3 years of law school and they all put up with me for those 3 years. So I appreciate all of you for doing that.
Very good. All right. So a couple of other things. We will sign the paperwork and make sure that that all gets down to the clerk's office so you can become official and ultimately get your P number. And Madam Clerk, I would ask that you would please, well, why don't you come forward and let's sign the paperwork? And then you can do that. And I think it's down there. There are pens right here. I think you have to sign, or have you already signed, or do I have to sign?
Sign and you have to sign.
Okay, then I'll let you sign first. Take those and we'll, that I think is yours. You need it?
Yeah.
Okay, well, I was gonna give it to her. It looks like hers. All right, we'll make sure that all of that gets to you. All right. And Madam Clerk, what you would please do is please prepare a transcript of these proceedings. Please send that, make sure to get the home address of Ms. Serbs so that we can send that to her so that she will have that in posterity. We will also produce, since she wanted to have it this way, a video so that in those dark moments you can revisit. Okay. All right. Thank you. That will end the special session of the Washtenaw County Trial Court. All right. Court does call the case, People versus Rebecca Valentine.
And here, ladies and gentlemen, here, I will pause it for a second because Ms. Valentine is the reason for the next part of the video. The whole next section of the video is going to start off with the first Simpson appearance that she had, which was a previous video that I produced. Then there's an update to that that happened just 2 weeks afterward. And then there's another update in Judge Collins' court from November the 13th. So buckle up, ladies and gentlemen. Miss Valentine is a fun one. We got about 15 minutes with her. I'll be back with you after that.
That's Lonnie for the people. Assistant Public Defender Chinaze Carey. I can really on behalf of Rebecca Valentine, Your Honor.
Valentine, can you state your name, please?
Yes, and I did say I want to represent myself, so I don't know where that communication was failed. Rebecca Valentine, I don't wish to have an attorney represent me.
Okay, you want to represent yourself in this matter?
Yes,
Okay, so what do you want to do today if that were the case?
what are my options?
Pardon?
What are my options?
I can't apprise you of that, ma'am. I can't give you legal advice.
Probably just adjourn it for 2 weeks and they could let me know what they want to do next.
Have you spoken to the public defender or an attorney at all, ma'am?
Yes, she was very inconvenient and not communicated with me, and I let her know I would like to represent myself. I think that you're allowed to tell me like reasonable information, and then I can make a reasonable choice about my own representation. Is that not my right?
Well, thank you for letting me know what my job is, but that's not how it works.
You're welcome, but I would think you should know this already.
October 24th, 2024, 9 a.m.
Sounds
I'll
good.
consider that a waiver of her time requirements. Bond continued. Thank you.
You're welcome.
Should I put anything on the record?
What'd you say?
I guess it would be fair. For the record, Your Honor, I did try and reach out to Ms. Valentine.
How'd that go?
It didn't go very well, Your Honor.
Oh, I'm just asking. I don't know. You don't have to answer me. That would be privileged. Did it go as well as my conversation just now?
You actually heard her voice, so.
Oh, okay. That must be part of my charm. Court calls case People versus Rebecca Valentine.
Good morning, Your Honor. First, Public Lena Anderson with and on behalf of Ms. Valentine. Ms. Valentine, please state your name.
I'm defending myself, Rebecca Valentine, and I want to enter a guilty plea.
Excuse me?
Your Honor, I spoke with her this morning. She advised me that she wanted to represent herself and did not wish to be represented by the Public Defender's Office.
Is that a correct statement, ma'am?
Yes.
All right, couple things we have to do here then. I do have to advise you that you are before the court on 2 charges of assault on a prison employee. Do you understand the nature of those charges?
Yes, they started it, but I ended it, and I'm guilty, and I want to say I'm guilty.
Ma'am, I'm also going to advise you that you should refrain from saying anything about the offenses, as anything that you say can be used against you in this matter.
I did want
You
Go
also
ahead.
understand that each of these counts is a felony, punishable by up to 5 years incarceration and a $250 fine plus court costs. You understand that?
Yes, I do understand that.
All right. You also understand that there can be great perils in representing yourself in this matter?
Yeah, but I accept that. I don't really
And
think there's that
you
many
also-
perils.
You also understand that in doing so, that you would be held to the same standard that an attorney would be held to regarding knowledge of the court rules and knowledge of the proceedings.
That sounds pretty fair.
All right. So your intention is to represent yourself in this matter?
Yes, sir, and plead guilty right now.
You understand, you could please not interrupt me, but if you understand also that if at any time during these proceedings that you wish to be represented by counsel, that you can request that of the court, and the court would appoint counsel to represent you if you could not afford to hire counsel. You understand that, ma'am?
Yes, sir.
And so you wish to proceed today without counsel, is that correct?
Yes.
Public defender is permitted to withdraw as counsel of record, defendant to represent herself.
Thank you, Your Honor. Do you need an order?
Pardon?
Do you need an order?
Please.
I'll get that to you right away, sir.
Okay, ma'am, what do you wish to do today?
I would wish to enter a guilty plea.
All right. If you wish to enter a guilty plea, you're gonna have to waive your right to a preliminary examination, proceed to circuit court and enter the guilty plea there.
Okay.
So you wish to waive your right to have a preliminary examination in this matter?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yeah.
You understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Ma'am, you understand, and it has not changed from the time of your arraignment to the time that I had just read the charges. You understand that this is, at this point, the circuit court arraignment. You understand that, ma'am?
Yes, sir.
The information in this case alleges that on or about November 26, 2022 at Huron Valley Correctional Facility, count one alleges that you did commit an assault on a prison employee, that being a Tracy Maupins. You understand that charge?
Yes, sir. I punched her in the head 3 times.
Excuse me?
Yep, I did it. I punched her in the head.
Well, you understand what you are charged with.
Yep, punching her in the head.
It's a felony punishable by up to 5 years incarceration and a $2,500 fine plus court cost. You understand that, ma'am?
Yes, sir.
The information also alleges that on that same date at that same location, that you did commit another offensive assault on a prison employee, that being a Lauren Hales. You understand that charge, ma'am?
Yeah, I punched him in the head 3 times too.
I'm also going to advise you that you should refrain from saying anything about the offenses in this case, because anything you say can and will be used against you. You understand that, ma'am?
Yeah, but I'm already saying I'm guilty, but I understand.
The second offense is also a felony punishable by up to 5 years incarceration and a $2,500 fine plus court costs. You understand that?
Yes, sir.
You also understand that, as I had indicated before, that you do have the right to be represented by counsel. You cannot afford to hire counsel. You would be appointed counsel to represent you. You understand that?
Yes.
All right. This time, ma'am, what I'm going to indicate is that you're standing mute to these charges. That means you're not at this time saying anything about them, and I will be entering a not guilty plea. You understand that?
No, because I want to say I'm guilty. And I
And
thought we
you've
found
said
it
it-
over to
you've
circuit
said it
court,
all
so I.
Ma'am, you understand that for the purposes of this arraignment, you're not saying anything about them, meaning that you're standing mute. By law, that means that the court will enter a not guilty plea on your behalf. You will proceed to circuit court and then you will do what you wish.
Oh, I thought we just switched over to circuit court so I could do that.
Well, we kind of did. But I'm
So I
not
don't
doing the plea. The fact that you don't understand may be why you need an attorney.
I
But
don't need an,
I can't force you to have one, so you're gonna proceed on your own. Do you understand what I have just said?
yep, you're not doing what I said.
Or will indicate the defendant is standing mute to both charges. I'll enter a not guilty plea. Pre-trial in this matter will be set for
November 13th at 1:30 before Judge Conlon.
good luck. November 13th, 2024, 1:30 before Judge Conlon, and I'm sure Judge Conlon will be more than happy to take your guilty plea, ma'am. All right?
Okay.
Bond in this
Have a good
matter
day.
will continue. Thank you.
Thanks.
Number 43, People versus Rebecca Valentine, 24900 FA.
Sorry, thank you, Jonathan Evans, on behalf of the people. You know, if I'm not mistaken, I believe that she's representing herself.
That is true. That's my understanding as well.
Ms. Valentine, if you can hear us, can you put your name on the record, please?
Rebecca Valentine.
All right, Ms. Valentine, is it your request to represent yourself?
Yes.
Okay. Today is the date and time set for pretrial in this matter. Despite the fact of your location, we oddly do not have fingerprints in this file. So you're going to need to work with somebody to make sure that fingerprints get attached to this file, okay?
Somebody must know how to do that because I don't work here, but I want to plead guilty.
Yeah. Yep. Couple of things, Your Honor. I know that Ms. Valentine was at the PCC and she had previously indicated a desire and wish to plead guilty as charged. It's going to be important that she recognizes that she does have the right to have an attorney, and that if she chooses to represent herself, that she knows that there are court rules and expectations that would be put upon her. Oh, I'm starting to lose my voice. And that she's going to have to comply with those expectations. I will say one thing that I know that Ms. Valentine might not be aware of, maybe she is, I don't know, she is with 2 counts of assault on a prison employee. I would tell her that I have her guidelines calculated at 12 to 24 on each of the counts, because this is something that happened in a prison. If she were to plead guilty, they would run, and I believe that they would run consecutive to her underlying charge. And it would be one R&O to run consecutive, and then a second R&O to run consecutive. So I know that
That's tacking on an additional 4 years.
right, so that's, I want to make sure that she understands that's clear. My understanding is that her maximum out date is 2026. So, you know, if there's no plea or if there's no sentence agreement or no negotiation between her, and it's difficult for me to get in touch with her because she is in the prison system to have any of those negotiations, she could be, you know, adding on a number of years beyond her parole date, which might be an unintended consequence. So I want to make sure that she understands all of that. And if she understands that, if she's going to represent herself, understanding the pros and cons of that, she's free to make that request. I would not recommend it, but.
Well, here's the deal, Ms. Valentine. There's a lot at stake right now, and in the true nature of the blue light special, happy days for the public defender. I'm appointing the Washtenaw County Public Defender to represent you in this matter until the next pretrial. So I'm going to give you an attorney.
I don't want representation from anyone besides myself, and I want to enter a guilty plea. That's my right, and that's what I want to do.
Okay, well, I'm going to adjourn this to December 18th to do that then. So I'm going to let you think about what Mr. Emmons just said. I am appointing
I
the
heard
public
his little
defender.
interesting speech, but I'm not concerned about what he said. I told you what I wanted to do, and that's what I'm going to do.
Well, the fact that you identify my speech as so interesting makes me feel like somehow you're going to later claim that somehow you were unadvised. So I wasn't that interesting.
That makes
And
me
you have
feel like
certain
you're calling
rights.
me a liar, and I feel like that's not the case at all. It could actually be the other way around.
Okay.
I'm a very honest person. I'll be doing what I said I would.
Okay. Well, I'll see you back here on December 18th. And if you want to represent yourself and enter a plea that day, I will do that. But I'm going to give you until then to think about it. So that concludes the hearing today. I'll see you back here then.
Have a good day.
Number 19, People versus Michael Kyle, 24830.
Hold on a second, before we finish this completely, Mr. Emmons, if you could sum up what you just said in writing, and I don't know how you communicate that to the defendant.
I will.
Copy me and copy the court, and at least it's in writing then, your analysis, so that there's no question down the road, okay?
Okay,
Thank
thank
you.
you, Your Honor.
All right, I have, I believe, one more.
Okay. This is it. This is Superior Court 5 of Elkhart, Indiana. I believe. This is the second case of our series for the day. This is the secret case. This is a very interesting, how do I describe it? Angry tenant being evicted from their apartment, but the circumstances surrounding the tenant and the eviction are interesting, humorous. I think we've all had neighbors like this. Didn't want to have neighbors like this, but we're going to hear a lot more about it right now. Oh, go away, me.
8:15 hearing for Ashton Pines against Melissa Webb. This is 2403 EV 391. Do I have Melissa Webb before me?
I'm here. Good morning.
Good morning, Ms. Webb. And do I have Angelina Kennard? All right, Ms. Kennard. So I have both parties appearing. Ashton Pine appears by its authorized representative, Angelina Kennard. Melissa Webb appears in person for herself. This is 2403 EV 391. Ladies, I read all of the pleadings in this matter. I know that there was a filing yesterday by Ms. Webb, and I did read through, I believe it was about a 21-page document, so I'm familiar with what's in the record. First, I need to ask just to make sure that I'm following the Indiana Supreme Court order. Did both of you hear my announcement about the pre-eviction diversion program?
Yes, Your Honor. I did.
Okay, and I'll start with the landlord. Is there any interest in that program for this case?
No, Your Honor.
Okay, without there being unanimous agreement, I'll get into the substantive issues. If I look back, Ms. Webb, on the filing in this case, originally filed March 19th, there was a statement of claim, and it says non-compliance of 30-day notice to vacate. And then it also came along with a verified request for immediate possession. And in that verified request, it indicates that defendant refused to comply with a 30-day notice to vacate and also has not vacated the premises pursuant to a written notice given on February 14th of this year. Do you agree with those two statements, or do you dispute them now?
I agree that she has served me with the notice to quit, yes.
Okay, and you are still in the apartment, correct?
I am.
Okay. Now, if I look back, and my recollection of the date yesterday was that the 30-day notice was given February 14th, so 30 days would take us to March 15th, and then the claim was not filed until March 19th. So the 30 days was waited for. I want to set my eyes on the lease again real quick. All right, so the lease agreement was entered into, it looks like, last September or maybe shortly before, and the term was beginning September 2nd, 2023, and it was to run until September 1st of 2024. However, there has been a 30-day notice alleging that there's been a violation. I did see that there was a Goshen police report. So, Ms. Kennard, can you tell me a little bit more about the background reasons for giving the notice or the 30-day termination notice, as well as what you learned about the police report and activity?
I can't remember the exact date, but there was a situation that the resident was outside causing a disturbance. And a lot of the neighbors, 2 neighbors had called the police. She was arrested on site because she just was causing a nuisance. I believe it was just disorderly conduct of some sort.
And what I saw, just for the record, I saw disorderly conduct and resisting law enforcement as 2 charges.
Correct. I was not able to put the video that was given to me from a neighbor, and they weren't comfortable on top of that, but the video that we had seen, she had went across the street to building 18, knocked on doors, screaming across the street, screaming in front of the apartment, and just a lot of people was uncomfortable. And when the police had showed up, she did not comply with them and was threatening them as well. So I did not feel comfortable. That's a breach of the lease to be arrested on site. I believe it's in the bottom part, and it's also in the resident rights. And so we're just asking her to vacate the premises.
Okay. And did you personally observe any portion of the disturbances?
No, that happened late at night. My hours are 9 to 6. The video, I believe, was probably close to 10:30 p.m. or 11. I believe I can double check the blotter that was given to me, but it was brought to my attention the next following morning.
Okay. And I did not swear you in at the onset of your report to the court, but I'd like to do that now. So please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God?
I do.
All right. And what is your full legal name for the record?
Angelina Christine Kennard.
And Ms. Kennard, are you an employee of Ashton Pine Apartments?
Yes, Your Honor.
What is your job title?
I'm the property manager.
As property manager, do your job duties include keeping business records in the ordinary course of business that would reflect incidents related to tenants such as Melissa Webb?
Yes, Your Honor.
And did the business records of Ms. Webb's file show that there was an arrest record that was filed within it?
Yes, Your Honor.
Okay, and I think before I swore you in, we talked about 2 counts. I had seen the disorderly conduct and the resisting law enforcement. Is that your understanding of what the record showed?
Yes, Your Honor.
Okay, and would you please confirm all of the items that you represented to the court before I sworn you in? Do you swear that they were true to the best of your knowledge?
Yes, Your Honor.
All right, thank you, Ms. Kennard. Okay, Ms. Webb, it is your turn. I'm going to swear you in as well. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I absolutely do.
All right, and what is your full legal name for the
Melissa
record?
Webb.
And now, Ms. Webb, you are the defendant and the tenant who signed the lease with Ashton Pines Apartment. I think it's Head Core Management Corp. Is that correct?
Correct.
All right. And as far as you know, your lease was to run from September of 23 until September of 2024, correct?
I had an annual lease, yes.
And did you receive a notice in February asking you to vacate within 30 days?
It was in my door when I received it. It had been there for a couple of days.
Okay. And when did you first see it?
So it was January 11th. It would have been Super Bowl Sunday was the night. If we go back into the paperwork, the police blotter, that's what I'm searching for right now. When Angelina said it was about 10:30 at night. What is not discussed is that my son ran away at 10:30 that evening. And in the blotter, it shows a chips right before my name, which would be my son. There's a lot of misconduct that is going on with this case, and I would like to set this case for trial.
Okay. Well, because this is an immediate possession hearing, typically those issues are the type that get heard on a preliminary basis before a full-fledged trial.
Okay.
And if you've heard the hearings before yours, most of them took 3 to 5 minutes. Occasionally when there's an issue where there's a contested fact, I swear people in and I gather preliminary evidence to make a determination. By all means, there can be a follow-up trial on all issues, not only money damages, but also permanent possession of the premises. But at this time, given the request for not only immediate possession, but emergency immediate possession, I'm inclined to hear additional evidence and consider the facts that have been alleged already today. So I will ask Ms. Webb, you did make a filing, it was just yesterday.
I did.
And one of the requests that you made was to cure certain violations. And
Yes.
Can you explain to me what you mean by that?
Those violations, the misconduct and the 2 arrests, I am very unaware of either one of those. That's why you see the drug tests at the very back of the filings. There are some foreign substances that are inside of my system, and I have an ongoing investigation regarding that, and that has to do with my behavior. I've also given Angelina many times in the very beginning. I sent her a paper from my doctor noting what my diagnosis was and the issues that I deal with on a day-to-day basis. I had also sent her a complaint form on August 25th of 2023 stating that I was uncomfortable. There was a lot of stuff going on in the apartment above me, that I had wished to either her be moved or I be moved, and for Indiana law, it's her responsibility to make sure that I'm safe and comfortable in my home, and that did not happen. It progressively had gotten worse. Per each complaint that I would make, I would get one in my door. If you see the first general violation, I filed 8:25 in the morning, and then I get a violation on my door, 8:25, regarding my service animals, which were said to be, and this wasn't filed in the paperwork, and I went back into the office and asked for this paperwork, and it was still not given. They'd told me that I needed to remove my service animal, which is a HIPAA violation. Not only that, from Jennifer, the other woman that works in the office, as well as Angelina, their statements are not true statements. I have video
Which
footage.
ones of their statements?
So Angelina states that, if you give me a moment, there's a lot of paperwork here. And I had it in order.
And if it makes you feel any better, I did read through it is 21 pages, and I did
There's
read
a
through
lot.
all of it yesterday when it came in.
It was pretty intense putting it all together, but, okay, so her claim that I had, her last police report, forgive me, I have anxiety, so this makes me nervous. She had said that I had trespassed. I have a full video of me walking from my car to the inside of the office where I was speaking with Jen. Angelina had, on her very own, come out of her office and intervened, called the police, and at any rate, I have a video of that. It's a 9-minute video. Now, the other one from Melissa Webb is in the office. I am typing this documentation. This is Jennifer Prater. I have a 25-minute video of the entire conversation that I was having with Angelina right here, right next to me. And what she is stating in her statement right here is false to what actually happened.
Okay. Now, ma'am, I'm going to redirect you a little bit. I know that there were background issues with your service animal. And I know that there were issues with the tenants above you making noise and dropping what appeared to be bowling balls at all hours of the night. So I don't discount any of those things. Sure. But the one most relevant issue to this immediate possession hearing is whether or not there was an arrest for disorderly conduct and resisting law enforcement on the premises.
I have no recollection of any of that happening.
All right, so if you have no recollection, and if there are business records, and if the court takes judicial notice of there being an arrest record on file, what I then have is a plaintiff providing some proof and a defendant saying I have no knowledge. And in my opinion, if the plaintiff is credible, they've met their burden of proving one of the elements to go ahead with a 30-day notice.
I believe that there is a lot more to the story, considering that there's been a plethora of misconduct in the complex and in the office itself.
Okay, and what kind of misconduct?
I'm not sure that I feel comfortable speaking about that in front of people that don't know the situation that is going on. I have grieved the Housing Authority about their decision. I have also contacted the Bremen State Police Post, and they are investigating the situation at hand.
Okay. All right. Any other information that you have that would refute the existence of charges being brought against you for incidents happening on the premises?
So the reason that I had asked in the original, my submitting the following paperwork, to cure these violations is because I feel like these violations are going to go away and they are not going to stay, which would be why I would ask for a hearing, an additional hearing.
All right. So just a little legal explanation. There's a difference between proving something by preponderance of the evidence, which is just a fancy way of saying more likely than not in a civil setting, like in an eviction or any other lawsuit, versus a criminal setting where the burden of proof is beyond a reasonable doubt. So the state or the prosecution has to explain that in a manner that would convince, for example, a jury to believe a defendant's guilt. So it's very possible that a defendant's criminal charges could be dismissed, but that doesn't change the fact that a probable cause affidavit might have been filed or a finding enough to arrest existed. So if that, just for example, if you see scales of justice and someone tips them ever so slightly to be 51% versus 49, that's enough for a civil standard, but it might not be enough to meet the criminal standard. So even if I were to assume today that the criminal charges would be dismissed because, for example, the prosecution did not believe they can prove their case beyond a reasonable doubt, that doesn't change this court's weighing of the evidence under the civil standard. I know that's a lot of legal jargon I've just thrown out there, but I just wanted to explain that to you.
I'm jotting down.
So one thing that courts often do when there's an issue of immediate possession or some kind of issue that needs prompt attention before a full-fledged trial is to make a determination on a preliminary basis and set a trial for a later date. And sometimes, for example, if a court were to find that a plaintiff or landlord is entitled to immediate possession, they will indicate that that would go through upon the posting of a bond to ensure protection for a defendant. So,
I'm sorry, I don't quite understand. A posting of the bond?
Of a bond. So let's assume that I found today that the plaintiff has met its burden of proving that there was an arrest on the premises, that you were arrested for criminal activity on the very property, and that the lease says if that happens, then after a 30-day notice or otherwise, the plaintiff is entitled to immediate possession.
Up to the management's discretion.
And that's exactly what the lease read. I read that provision carefully yesterday. If I make that finding, then technically a plaintiff or landlord would be entitled to immediate possession. Now, I recognize I might have done so at a 10 or 12-minute hearing instead of a 2-hour trial. So one thing that courts will do is to say, recognizing this was done on an emergency or immediate possession type basis will allow for an eviction to go through. But if it's determined at a full-fledged trial after reviewing all evidence that this decision was wrong and that the defendant should have prevailed, the court at this stage, this very stage today, could require a landlord or a plaintiff to post a bond so that if you are inconvenienced or otherwise harmed by a result of this quick decision today, that you would have some funds reserved with the clerk of court to be used for your benefit down the line. It doesn't change a preliminary decision, but it's meant to compensate if that's deemed appropriate at a later time after a full-fledged trial. So that being said, Ms. Kennard, I'm not sure if you've ever had to post a bond to get an eviction. We don't usually require it when there's an agreement of being delinquent in rent or something that's pretty simple, but in a case where someone has video evidence they want to be seen, etc., sometimes we require that. And I would be inclined to grant the plaintiff's request for immediate possession upon the posting of a bond. And we have a 30-day notice and we might not have a hearing for another 30 days. I believe it might be appropriate. Let me go back and look at the lease. What? $875 is the monthly rent. If I triple that, 2,400 and another 225, 26. I'm going to round it at $2,500 bond. You can go through an insurance company that will allow you to pay some portion of that. Sometimes it's roughly 10% to gain the protection, so it's not as if the full $2,500 would need to be posted. But for a bond by an insurance company that grants that, I will issue a writ of restitution, make that finding of immediate possession in favor of the landlord. I believe you proved your case, but because Ms. Webb has asked for a full-fledged trial, I'm going to require before my order of possession is effectuated, and before we even set the date for the writ of restitution, it would be 10 days after the plaintiff posts the bond of $2,500. And the next thing I'll do is I want to look, if there's a money damage hearing, there is one set for May 7th at 9 a.m. I want to vacate that date.
Okay.
Because I think we need to have a trial on the issue of immediate possession before we talk about any money damages that might be owed in either direction. So we'll vacate the May 7th hearing. And I'm going to refer this matter to Magistrate Dean Burton. He handles most of my small claims trials. He has the ability to schedule a full morning or a full afternoon and give 2.5 or 3 hours down the line. So I'm going to ask if we can ask Magistrate Burton to expedite this. I'd rather not hear it in 2.5 or 3 months, but to hear the immediate possession issue, and then we'll reschedule damages after that. Ms. Kennard, do you have an idea of how long it might take you to post a bond? Would you think it could be later this week or next week or?
It'll be today.
Weeks ahead, okay. Then what I'll say, Ms. Webb, is whenever that bond gets posted, that's going to be my trigger to issue a writ of restitution that gives you 10 days to vacate. So you might want to be moving along that path while you wait for that. I will keep an eye on, I'll make a note in my calendar to be on the lookout for the posting of the bond. And I'll act from there. I'll start with the plaintiff. Ms. Kennard, any questions about my decision?
Do I pay it to the clerk's office?
You can pay it to the clerk of court right across the hall from here.
And then just as a question for myself, because there's been, and what I've given to the court has some of my personal information on it, and she has gotten it some way, somehow. When I give the court something, should I redact my?
You always have the ability to redact personal information like, social security numbers, bank account numbers, and things like that. Whatever else that might fall under, I think it's Administrative Rule 9, if I'm not mistaken. What typically is the process, and the clerk can further explain, is you will file a full-fledged document that is deemed confidential.
Okay.
And then a redacted or blacked out document taking away the private information, and that one is public record.
Okay.
So there'd be like 2 versions of a confidential document.
Okay. Gotcha.
Any other questions?
I just had the IERA that you were speaking with the gentleman before. Is that something that I would need to look into, or is the $2,500 bond something that helps me?
So the program that was being referred to in a prior hearing was, from my understanding, related to rental assistance for financial issues. So if somebody is behind on their rent and they want to apply for some government assistance or other program assistance, they can have time to do that. Here, the issue is not non-payment of rent. They have brought suit under a violation of lease terms. So I don't believe that any kind of rental assistance program would be applicable to your case.
Okay, because my housing voucher was pulled out from underneath me, and it was paid up until the end of just yesterday or a couple days ago. I just wanted to make sure all my bases were covered.
Okay. So and from my understanding of the program that was referenced, the IERA, that appears to be a rental assistance program. I don't think it's applicable here.
Okay.
Do you have any other questions?
That's all.
Okay, you should both pay attention for, and I know there's another question here, to notice of the hearing for the immediate possession trial before Magistrate Burton. Another question from Ms. Kennard?
Well, after I post the bond, there's 10 days, and then the sheriff will deliver the writ.
So upon your posting of the bond, and I'll ask my staff to pay attention, and I'll have it on my calendar to circle back for it. Once I see that's come through, I will issue a writ of restitution, which gives the standard 10 days to vacate. So if that's later today, the out date would be Friday, April 12th. If it's, tomorrow, it's 10 days from tomorrow, Saturday the 13th, et cetera.
Okay.
Any other questions from either side?
So it's 10 days.
10 days from the issuance of the.
She seems pretty confident she's going to drop the money. So.
Right, so assuming it does come in later today, as she's indicated she's planning on, it would be 10 days from that posting, assuming I turned it around before business hour, 4 o'clock today. If it gets done tomorrow, then it will be 10 days from that date.
And just one more thing, if there is, I am so sorry, it just left my head.
It's okay.
If there is a conflict of interest in any of the courts, how do I address that?
Okay, you certainly can file a motion with this court asking me to disqualify myself. I'll give you the opportunity. A conflict of interest usually relies if a judicial officer has some prior attorney-client relationship with a client.
Okay.
Ashton Pines Apartments was never a client of mine in my 24 years of practice, so I don't know how there could be a technical conflict of interest for me, but you are certainly free to explore that. Quite frankly, you're welcome to ask me any question that you'd like.
Or even magistrate, or even Dutton.
Magistrate Dean Burton, are you aware of Magistrate Burton?
I'm not comfortable answering that.
Okay. Well, if you believe that Magistrate Burton could not be a fair and impartial judicial officer hearing this case, I'd ask you to let me know now because I can make other arrangements.
I do not feel comfortable.
Okay. And is that because of a prior attorney-client relationship in some way?
Recent findings.
Related to him or related to?
We are actually out of another court, Superior 4. He was my judge just a couple days ago regarding my driver's license, my conditional license. I know this doesn't have anything to do with the hearing, but it had expired and he had refused to
Oh, you might be thinking of Magistrate Ditton. Magistrate Ditton hears the criminal matters.
Okay.
Magistrate Burton is only a civil magistrate.
Completely different guy.
Yes.
I think it is Ditton. I think you are right.
Yeah,
Okay.
he is the one who has the jail hearings and otherwise presides over a lot of the driving related issues. That would be Magistrate Eric Ditton as opposed to Magistrate Dean Burton in this case.
I'm so sorry.
That's okay. All right, so I'll leave my referral to Magistrate Dean Burton. Any other questions from either side?
I'm good.
Okay, thank you, folks. I wish
Thank
you all
you.
best of luck.
All right, councils, Arthur and Barbara, come on.
Okay, time out. Hold on. Let me do this. And I'm gonna go ahead and
All right.
pause it there. And first off, before we get started in with Judge Garcia, who is another one you may have seen around, but you don't see on my channel a whole lot. She's great, by the way. I want to apologize for what you're seeing right up here. It's going to be very blurry because in reality, when you're looking at her Zoom feed, you have her on this one side over here. And then you have a split screen. You have one camera up here and another camera over here in the other box. So there was nothing in the top box. It was just nothingness. So I did my best to try and crop up things, but that really messes with the what we would call the resolution of the video a little bit. But you're gonna get the gist of everything going on. So what we have here is another civil case. And I really don't want to get into the guts of explaining this, but let's just say that whole vexatious litigant comment that we just had in the previous case is going to be very, very applicable to what you're about to see. So let's go ahead and get started, shall we?
Councils, Arthur and Barbara, come on up.
It's real to send. It's our motion to take that side?
Yeah.
Okay.
All right, give me 1 minute. Let me get the motion up so we can see what's going on. And it does look like we have a couple of things to address, so let's do. All right, and Mr. Arthur, can you hear me?
Yes, Your Honor.
All right, Mr. Arthur, we're here right now. We're gonna do one step at a time, okay? So right now, we're here on the motion for sanctions, and I'm gonna open this up. Let's see here, motion for sanctions. Are you familiar what a motion for sanction is, Mr. Arthur?
I didn't hear you, Your Honor.
Are you aware of what a motion for sanction is?
Yes, Your Honor. I was
Okay.
going to ask the constable to ask you a question for me, please.
And what is that?
What is the end state that I have free will to litigate in this suit?
I'm sorry, I didn't understand the question. Can you repeat it?
As the plaintiff, do I have free will to conduct this hearing? And that's what it's a question of law, Your Honor.
Okay, but I don't know what the question is. Can you conduct this hearing how?
At free will to pursue the nuance litigation that was filed, but we're filing, we're pleading the merits of the legal interferences, not the merits of the case.
Exactly. We're here on pretrial motions.
So otherwise, I'll have to plead the fifth if I cannot have the free will to pursue, to file my pleadings with the countersuit of the sanctions against the defendants.
Well, I mean, you can file whatever you'd like, but have you filed them?
Your Honor, I believe he's been labeled a vexatious litigator, and under the law, he's not allowed to file anything in any court.
And he's been formally labeled this as with other courts, or
With
what
one
is that?
court, so under CPRC, Civil Practice Remedies Code 11.101.
Go ahead.
To the judge, just for quick reference for her. And this. It's a court may on its own motion or a motion of any party. This one's got some. Oh, I'm sorry. Apologize for that. Court on its own motion, a motion of any party may enter an order prohibiting the person from filing pro se a new litigation in a court to which the order applies under this section without permission of the appropriate local administrative judge described in section 11.102. So the administrative judge knows about this. And we have an order from 2017 labeling him vexatious litigator. He's supposed to pay $7,500. I'll have that order for the judge in just a second.
Okay.
Under D, a pre-filing order entered under subsection A by a district court, which is a district court or statutory county court, applies to each court in a state. And so he doesn't have the right until he pays the $7,500. And I will, would you want that order right now from the district
Yes,
court?
sir. I need to review all of these orders right now. And so, counsel, what is your end result in this hearing? To get this case dismissed or to file sanctions?
Well, Judge, I read this. I read this since I filed my sanctions, and so I believe I had to bring that to light before I brought up any sanctions to you. This may preclude me from asking for sanctions, but it certainly doesn't preclude you from holding Mr. Rackwitz in contempt, because he's been in contempt 5 times in district court, and here he is in contempt with you. Let me get you that order.
And fact, what has district court found when they found him in contempt? What are the punishment? Is that the $7,500?
$7,500 is what he needs to pay for attorney's fees and costs in order for him to file and proceed with his suit in district court. Okay. And this is nothing more than his attempt to form shop from district court to here.
Mr. Rackwitz, I'm sorry, counsel, were you done?
I am. Now I'm going to hand you this. Now I have an entire packet for the judge. I'm going to leave. I don't think we want to scan all that in, but I'll leave it for you, Judge.
Okay.
And I had that same packet from Mr. Rackwitz. If he so chooses to take it, I can give it to him right now. But I'm going to lay it right up at the bench.
Letty, if you could scan the orders in, though, the most important papers, that I do need to see those.
Yes, Your Honor.
And then,
go ahead. Everything I've handed you. And I'll put it on this bench.
All right, and Mr. Arthur, do you have anything to say about these motions that have, or let me rephrase that, about these sanctions that have been rendered already from previous and higher courts of Bexar County?
Through the constable, this is a filing that this case, the judge has jurisdiction, supersedes the counsel, opposing counsel, because now is a federal investigation by the U.S. Postal Workers. And I also have something else that due to the litigation that was unknown to me, that the defendant's husband has passed away and the son, father has passed away. And at this time, I think it's inappropriate to be conducting any legal action for a grace period at a moratorium so that they may grieve without having, and that was the reason I filed my counterclaim against the legal counsel. And that's all I will say. Any further, I shall be silent.
Okay. All right, let me, counsel, wait till I get my exhibits and then we'll go from there. And then counsel, this case in county court, is it an exact replica of what's going on in this court?
Yes, Your Honor. I realize it's not a certified copy. I apologize for that. I should have gotten a certified copy. But that is the exact replica of what I've seen online and before. And that's I'm representing to you, that's a copy of the actual order.
But the merits of this case in county court are exactly the same merits of this case.
I've got to be, I can't tell you that, Judge. I don't understand any of his pleadings.
Okay, give me 1 minute, counsel. Hold on 1 minute. Okay. Mr. Rakowitz, this case pending in 2017 with this order signed by John Mead. Let's see here.
Judge Stryker.
Yes, Judge, I'm sorry. Are you aware of this order, Mr. Arthur?
There is an order, Your Honor, that I was not even aware of. I didn't find out about it until recently when a deputy of the clerk presented to me that it was somewhere tucked away. I never received it.
Okay, but you're aware of it now?
I am aware of it now.
Okay, and has the $7,500 been posted?
I plead the fifth, Your Honor.
Okay, all right. So from county court, and counsel, I'm assuming this judgment is still valid, correct?
Your Honor, that case is still going, and that judgment will be valid within that case as long as it's live.
Okay, and Mr. Arthur Rakowitz, is the case pending in county court that this order is referring to, is it based on the same merits of the case here in JP4?
Could you, I didn't hear that.
So the case in county court, for the case that you have the order for the $7,500 security bond, the case against you and Barbara Pittman and Wayne Pittman in county court, is that case based on the same facts as this case in county court, in my court?
No, Your Honor.
And how are they different?
I plead the fifth, Your Honor.
Okay, since you're pleading the fifth, then I'm gonna make my own determination because I'm giving you a chance to explain and you're not, and you have that right to plead the fifth. But at that point, I will make my decision based on that then.
It is not, Your Honor, due to.
Okay, Arthur,
Yes,
I'm gonna stop you right now. I'm not playing your games. If I ask you a question and you choose to plead the fifth, then that's your answer. We're not gonna go back and forth based on, well, if I don't answer, this is what's gonna happen. You either gonna answer and you're gonna stick to your answer, or I'm gonna make you stick to your answer. We're not going back and forth. You choose to plead the fifth, then you can plead the fifth. When you choose to answer the question, you can choose to answer the question. I'm going to ask you the question one last time, and I will take your answer at face value. Is the case pending from 2017 in county court that you have this order for sanctions based on the same facts of this case pending in JP4?
No, Your Honor.
All right. What is the difference in facts?
The 2017 in the district court, Your Honor, is to exit out of the court because there is a dismise. The late Mr. Pittman is no longer part of the suit, and I have a declaration that I was just found, and it's based on the sanctions that I filed against the Mohar law firm because we originally had an agreement, and he's been sidestepping and avoiding me, and it's due to the comment that I made earlier that Mrs. Pittman and her son are in a state of grievance right now. And it's not appropriate to have myself. I want to be held harmless of any personal injury to the conscience of Mrs. Pittman and of the son, because I have the utmost respect for Mr. Pittman. For one, he's a veteran, and so am I. I was trying to legally withdraw Mr. Pittman as a veteran honorably so that there would be no legal whatsoever disgrace because of him being a veteran. To show my reverence is just as millions of other veterans that have fought for this country, the democracy.
All right.
And
so,
with
Mr.
that-
Arthur, give me 1 minute. Hold on. Counsel, he
Yes,
keeps
Your Honor.
bringing up this delay of the case due to your clients needing a moment to grieve.
No, Your
Of
Honor.
course, I have to ask you, are you in agreement to this continuance?
No, Your Honor, I don't believe we are.
Okay, so Mr. Arthur, I understand that you're wanting a continuance based on the respect aspect, but again, that's not a legal reason. So today we are going to proceed forward. Council is not wanting to delay this, probably for the same reasons you're saying. They want this over with and done with. So we're here now, and I have to determine if sanctions are valid enough or not. So give me 1 minute. Let me read the council's motion for sanction. All right, and council, she's accumulated $4,000 in attorney fees.
Yes, Your Honor.
And council, talk to me about mediation.
Okay, we have tried to, or he came by our office and he asked to negotiate, not mediate. And I said, you know, I'm welcome to that idea. And, you know, let's discuss dates. And we didn't discuss dates that day. Mr. Rakowitz does not have an email. He doesn't have a phone. The only thing he has is a post office address. So if I send him dates that I'm available, by the time he answers via regular mail, I don't think I'd have those dates anymore. So he had motioned the court for mediation, and I am fine with the court ordering us to go to mediation. I'm okay with that. I'm not saying that we can't mediate. I've never turned down mediation. I can't set up and schedule a mediation with somebody via regular mail. It's just impossible. And I don't understand why he doesn't have a phone or email.
So, Mr. Arthur, are you in agreement to setting up mediation at the Bexar County Dispute Resolution Center?
Your Honor, I have tried. I have a document here.
That's not what I asked you. We're here now. Are you willing to go to mediation at the Bexar County Dispute Resolution Center? Yes or no?
Mr. Wilson will show up and hold on to his to the agreement. I would be happy to, but if he doesn't want to, there's no use in me, Your Honor.
Okay, so nobody said nobody wanted to. Council has literally just testified that he's willing to mediate. So let's stop with the opinions, okay? We're here now. Both parties have already mentioned in open court that they're willing to mediate. Is that correct?
Yes, Your Honor, there's also something that you weren't aware of that Mr. Wilson failed. Mr. Wilson, when I met in the office, are you familiar with the Roberts Rules, Your Honor? I even went and bought a book of Robert Rules because he presented that to me and I wanted to make sure that I was in compliance. And I haven't heard since I got dates in August, and on the second letter, the same way. And so I've done everything I could, Your Honor, to try to.
Mr. Arthur, do you have a point of contact?
We have, Mr. Wilson knew that I don't have a phone, that I do things by correspondence. I've even corresponded with legislators, and that's my only means, Your Honor.
Okay, so I'm going to tell you this, Mr. Rakowitz, because the court's done wasting time on this case and we need to either get it adjudicated or not. The Bexar County Dispute Resolution Center is going to pick a date. We will get with them. Letty, make sure you put notes on this. We will get with the Bexar County Dispute Resolution Center. We will pick out a date and there is no negotiation. Everybody will meet on this date. And at that time, if nobody is met or nobody shows up or one party doesn't show up, then I will reevaluate the sanction motion and we will go at the full extent at that point.
I agree with you, Your Honor.
Is that understood on both sides?
Yes, Your
I
Honor.
have no problem with it, Your Honor.
All right. Since Arthur, we aren't going to do this snail mail back and forth because that runs into an issue. And again, if you choose to do that way of method, I can't stop you from it. That is your right. But that limits us of what we can do. So we will pick out the date. It is not negotiable. Unless the world is ending, you will appear at that date. Okay? And that goes for counsel as well. Counsel, if you can't physically appear, you need to send somebody.
I will.
All right. So I will set up a date for mediation. Depending on how mediation goes, I will then address the sanction issues.
Your Honor, may I ask something of the court?
Yes, sir.
There is, during this past week, the court probably is not aware. I had back in 2013, I was involved in a severe head trauma of a shooting in the face. And due to that, there may be a medical condition and I won't really know until I'm seeking medical attention. And the individuals that perform the surgery are not locally. They may be scattered. It's imperative because even swallowing water is beginning to be painful and it's becoming a detriment. And I hate even bringing it up because it's even more detrimental because I found flies in my refrigerator yesterday after leaving the Bexar County Courthouse. But I don't have no choice. I need to keep the court informed, just like I have to keep the law enforcement informed. Unlike everybody else in this room, they can go to McDonald's and eat whatever they want. My food intake to maintain myself is special.
Mr. Arthur, what does this have to do with mediation?
Well, I may have to have surgery, and I don't want to disrespect the court that, okay, well, this is my open window for surgery, and I would like to find out. Monday is the date that we have a schedule with this medical provider, and I'll know something more definite. But if I say yes right now, agree, and then the medical provider will may not be able to perform that, and I'm running out of straws, Your Honor.
Well, you and me both, Mr. Arthur, because I can only do so much for you. This case has been pending. Never once has this been brought up. And all of a sudden now, right when we're doing mediation, this has been brought up. You're going to the doctors on Monday. I expect to hear something by 5 o'clock Monday of a tentative date for surgery before I call the Dispute Resolution Center. If I don't hear anything from you Monday and I set the date then I better get something from your direct doctor stating that you cannot be there on that date. Otherwise, you will be need to be appearing on that date.
I appreciate that, Your Honor, and I will, because my appointment's in the morning, and I will immediately come and bring it to your staff.
Okay, and then we will discuss it, and we will keep the council in the loop, and if the date is open, we will find a date to where it's before the surgery, so we don't have to wait for recovery time. We need to get this case moving.
Yes, Your Honor, I agree.
All right, we will reset it for mediation. Yes, counsel.
Do you need anything from my office concerning dates or scheduling or anything?
If you have anything, that would be great that you have open. I will definitely take that into consideration.
Can I send it to your email?
Yes, you can send it to my email.
Thank you, Your Honor.
Or the clerks, whichever email they give, she'll bring it to me either way.
Thank you, Your Honor. I will do that today when I get back to office.
All right, thank you guys. Y'all have a great one.
Consideration for Wayne, you wouldn't give it.
Do not talk to him. Do not talk to him. Mr. Warren.
Ethan, take care of that.
Yes, Your Honor. Thank you. Y'all have a good day.
All right. All right. All right is right. Last case of the day, ladies and gentlemen. This is a long one. This is a motion to find Mr. Hume in contempt for not paying his obligations. This is Judge Thornton. This is a North Dakota court. And this is an interesting case. Do want to throw this out there. Mr. Thornton is pretty plain Jane. He has a pretty even demeanor. I would call your attention to Mr. Samuel Johnson, who is the attorney for the ex-wife. Ladies and gentlemen, I don't need to explain it. You'll see why it's here. It's a fairly new one for my channel, but it's an interesting one all the same. Let's get it started.
Richland County District Court is now in session this November 20, 2024. The time is now 11:03 a.m. My name is Nick Thornton. I'm a district court judge for the Southeast Judicial District, which includes Richland County. We're conducting this hearing by reliable electronic means. I'm physically located in the Barnes County Courthouse right now. This matter is based or cited in Richland County. We're conducting it again by reliable electronic means. We are live streaming this event on the Southeast Judicial District's live stream YouTube channel. It is an open and public proceeding. Any member of the public or media can attend these proceedings by following along in the live stream YouTube channel. Matter the court is going to take up, scheduled for 11 o'clock today, is Hume v. Hume, file 39-2022 DM76. Present in court for the state, Jessica Rydell, Assistant Richland County State's Attorney. Mr. Hume appears by reliable electronic means. His attorney, Trent Barkus, appears from a separate location. Miss Hume appears together with her attorney at the same location. Her attorney's name is Samuel Johnson. We're here on an order to show cause. There is a motion for reconsideration or modification of child support that is not ripe at this time and scheduled for a later date. Court entered after a trial, a judgment and an amended judgment. The amended judgment was entered on March 6, 2024 as record index 386. Sorry, 387 is the actual judgment. There was a request for a contempt citation filed on August 12, 2024 as record index 390, again filed by child support for non-payment of support. The court issued an order to show cause, and that was mailed to the defendant. Ultimately, Mr. Hume's trial counsel, Jonathan Green, filed a notice of non-representation. The court held a hearing in which Mr. Hume was informed of his order to show cause rights. One of the important rights provided to Mr. Hume was the right to be represented by counsel at public expense for this type of offense if the state sought jail. At that hearing, which was held in the law enforcement courtroom in Richland County, the state did indicate that it would be seeking jail as a sanction for contempt. So the court appointed Mr. Barkas to represent the defendant and continued the order to show cause hearing. That hearing date came and went with a non-appearance with Mr. Hume, so the court issued a bench warrant. Thereafter, the parties filed a stipulation to quash the warrant because Mr. Hume was having some technical issues and did not make it to court based on the technical issues. The court quashed the warrant as record index 407. That bench warrant was withdrawn, record index 408. We're still here for that order to show cause. So, Mr. Hume, you have the following rights. I've read these to you before, but I'm reading them to you again just to make sure you remember them. You have the right to be personally present in court. You have the right to written notice of any allegations against you. You have the right to be represented by an attorney. You can choose to privately retain an attorney. You can apply for a public defender, and one will be appointed for you if your financial circumstances warrant it, or you can choose to represent yourself. You have the right to reasonable delays to prepare for an evidentiary hearing. You have the right to an evidentiary hearing where the burden of proof is a preponderance of the evidence and the burden of proof rests with the state. You have the right to a neutral and detached fact finder. The issues at an evidentiary hearing are whether there is at least one willful violation of the court's order, and if so, two, what the appropriate remedy for that violation should be. The rules of evidence typically do not apply at this type of a hearing. Any ambiguities in the judgment or court order are strictly construed against the government and in your favor. You have the right to confront and cross-examine witnesses against you. You have the right to testify or remain silent. You have the right to present witnesses and evidence on your behalf and to use the court's subpoena power to force witnesses to appear. You have a right to reasonable explanation of the dispositional options for the court. The court can choose to do nothing. The court can hold you in contempt, and if the court holds you in contempt, the court can issue either remedial sanctions designed to ensure compliance with the previous court order or punitive sanctions should the court find that to be appropriate. Before making its decision, the court will give you the right to speak and mitigation of punishment or in mitigation of punishment. Mr. Hume, do you understand your rights? Mr. Hume, I think you're muted. Mr. Hume.
It looked like he muted and unmuted, and I don't know if his volume is turned up or if he has a microphone.
Well, I see, Mr. Hume, can you talk? You're shaking your head, yes, that you can hear us, but we're not hearing you. Can you try again?
Can you hear me now?
Now we can hear you.
Yes. All right. Okay. Yes. Yes.
All right.
Yes, I understand my rights.
All right. Ms. Friedel, go ahead.
The state would call Mr. Hume.
Mr. Hume, if you can please raise your right hand for me. Sir, for the testimony you're about to give, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I need to hear you.
Yes. Yes, Your Honor. I swear.
You can lower your hand. And for the record, please state and spell your full name.
James Hume, Jameshume.
Ms. Friedel, go ahead.
Thank you, Your Honor. Mr. Hume, what is your current address?
817 5th Street South, Walpton.
Okay. And are you currently working?
Yes.
And where do you work?
I work for Redemption Construction.
And is that a business you own?
Yes.
What is your monthly income with your construction company?
Right now it's $2,400 is the last one I got, but I have to buy materials and everything with that.
Okay, so you're saying that you brought home $2,400?
I brought home, but that's what I had was given, and then I had to take that money and purchase items with it.
How long has $2,400 been your monthly revenue?
I didn't make anything the month before. I just got this job
When did you get this job?
last week.
Okay, so this is a job you are employed at that you do not own?
No, I got a client is paying me to do work for them.
Oh, I see. So it's a project. Did you bring any documentation with you today?
Yes, I have documentation.
Okay, do you have any record of your income for the last 90 days?
Yes, I do.
Okay, so what is your income for the last 90 days?
Last 90 days. So I $2,400 this month in November, and there was nothing in October, and then I think it was like $800 in September.
Have you tried to obtain employment outside of your self-employment?
Yeah, I'm actually taking classes to be a home inspector right now.
It looks like your current monthly obligation for child support is $2,041. Is that correct?
That's what the order said.
Okay. And I'm seeing a last payment that was received by child support was September 3rd, 2024 for $137.50. Is that correct?
Correct, yes.
Okay. So you have not made any payments since September?
No. No, I haven't.
I'm sorry, what did you say?
Made any payments since then. I'll be making
No
more.
payments.
I just got paid.
I don't know if Your Honor, if you have a copy of the ledger card.
No.
Okay. Do I have the ability to share my screen?
Yes. Mr. Hume, can you see the financial ledger?
Yes, Your Honor, I can see that.
Okay, so the one that we have received from the clerk of court is looks like it was dated November 7th, 2024. So it has your balance due up until November 1st, where a balance was $48,677.05. Does that look correct to you?
That's what it shows on the screen.
Okay. Have you tried modifying your monthly balance or your monthly obligation in this matter?
Yes, I've contacted child support. They told me that there's nothing they can do until 18 months from the order. They won't put me on a plan or anything like that. They told me the only thing I can pay is the court ordered amount.
Outside of your construction work, do you have any other source of income?
No.
And has there been any point of time where you were not physically capable of working?
I've always been able to work.
And have you given any thought on taking on any side jobs or regular employment to take care of your child support obligations?
Yeah, that's why I'm taking those classes for home inspector.
Okay, but you haven't applied for any other work, like to start a job soon?
No, I have not.
Okay.
Because I have sent out several estimates and I'm just waiting for them to be returned as approved or not.
Okay, I think I have no further questions, Your Honor.
All right, Mr. Johnson, any questions of this witness?
Yes, Your Honor. Mr. Hume, at the time of the divorce, the court found in paragraph 60 of the amended judgment that your net profit for the 3 prior years was $100,000, over $100,000. You understand that?
I think that's that's wrong. It's not a profit of $103,000.
I'm not asking you if you think it's right or wrong. I'm asking you if you're aware that when you presented your tax returns to the court at the time of the divorce, your child support was calculated based upon the prior 3 years of employment, and your net profit was over $100,000 each and every year. Do you understand that?
It's not my profit.
I understand what you're saying. I'm asking you if you understand in paragraph 60 of the amended judgment, the court found the court heard evidence that James Hume has received over $100,000 in profit per year for the past 3 years. You understand that?
Evidence.
And you also understand that in paragraph 87 of the amended judgment, the court found, based upon your tax returns, the income you submitted on your behalf, that your 3-year average was $103,745. You understand that?
It's incorrect.
In fact, the court determined that your net monthly income was $7,200 for 3 years based upon concrete numbers submitted by your attorney of your tax returns for the prior 3 years. Do you understand that?
Time, Sam.
Pardon me?
Your Honor, I'm going to object to relevance. I don't know how a prior proceeding that's already been decided is relevant on Mr. Hume's ability to pay at this current time.
I'm getting to there, Judge.
Court's going to overrule the objection at this point. Ability to pay based on average income. There's a question of whether or not Mr. Hume is intentionally underemployed in light of his prior 3-year average of self-employment income for the same business. So the court's going to overrule the objection on relevance grounds.
Thank you, Your Honor. Now, Mr. Hume, how much was your gross earnings just in 2024?
2024, that's this year?
Correct.
I think it's about $36,000.
Your gross earnings in all of 2024, you're claiming is $36,000, correct?
Right.
What are you claiming is your net income in 2024?
I have to find that.
Approximately. What do you believe your net income is?
About $8,000.
I'm sorry, what is that?
$1,000 is what I take home.
$1,000?
$8,000.
$8,000. So you're claiming in all of 2024, your net income is $8,000.
Yes.
Okay. All right. How much is your house payment, Mr. Hume?
It's $1,000.
Okay. And I noticed that the house was foreclosed on this year, and however, you redeemed your household, correct? And the matter was dismissed.
Yes.
Okay. And so if you only made $8,000 per year and we're already in November, that would be $11,000 alone just for house payments, correct?
What they did, you want to know what they did in order for me to do that, Sam?
No, I'm just asking you a question that I want
Hey,
you
anything.
to answer.
I haven't paid anything on it. They just put it to the end of the loan.
So you're claiming that you didn't make a single payment on your household in 2024.
Yes.
Okay. When banks do that, James, if in the event that you are telling the truth, and when they do that, as part of that agreement, is that you must make every payment on time thereafter from the date that it was dismissed. Was that your agreement?
That wasn't our agreement, no.
So you just don't have to pay your house payment. That's what you're trying to
I
tell
don't
the
have to
court?
pay it, Sam. They just moved it to the end of the loan and just extended it.
I understand that. That was several months ago. What payments at all, if anything, have you made on your house payment in 2024?
Haven't, Sam.
You've paid zero, James.
Yes.
Okay. So when are you supposed to allegedly make your next house payment, James? Did you hear that question?
Yes, Sam.
So what's the answer?
I'm not able to make a payment. I haven't made a payment. I'm already 2 months behind, Sam.
Okay. So are you current on your water, sewer, garbage, heat, cable, electricity, and cell phone?
No.
How much are your monthly utilities?
My water is 100.
Just total of those: water, sewer, garbage, heat, electricity. What's the total per month for those categories? Not individually, just total. I mean, is it like 500 a month, 600 a month, just approximately?
There's 600, Sam.
600? And then you have cell phone.
It's 200.
Pardon me?
200.
A few hundred.
200.
Okay. 200. Is your cell phone working today? Is it hooked up?
Yeah.
Okay. And so, which means that you've paid $200 a month all of 2024 because your cell phone's still working, correct?
Turned off several of my lines.
Yeah. But it's still, you paid about $2,400 or $2,200 for the year, just for your cell phone, correct?
But, yeah, I guess.
Okay. And your utilities are all in place. You got heat, you got water, you got sewer, you got garbage. It's all in place, right? Because you're sitting in your bedroom right now, correct?
Yes.
Okay. So that's another $6,600 that you've paid for all of those expenses, correct, James?
I haven't.
Pardon me?
I haven't, Sam. Quit assuming.
Okay, so how are you able to have electricity and not pay? How are you able to have heat and not pay?
Because I get assistance for it.
Oh, so you're getting government assistance?
Emergency assistance, yes.
Okay. So how much have you received for government assistance?
So they paid for my gas.
Gas for your house, you mean?
Yeah.
They paid for all of it?
No.
Well, how much have you paid, James, in 2024 for all of those utilities out of your own pocket?
I just looked this up. I was asked to bring my bank statement, Sam.
Well, you're saying it's about $600 a month. That'd be about $6,600, if I got that correct, for 11 months.
That disconnection notices. When,
yeah, $6,600 would be your utilities for the 11 months, $2,400 for your cell phone, correct? That's $9,000 just for those expenses, James. How much money in government assistance did you get to offset that $9,000?
got much government assistance.
Pardon me?
Everything's still behind.
I'm asking you how much you got total from the government to pay for any of those expenses, including your cell phone that we just talked about.
In October, that's when I got my gas paid for. And
How much money?
I don't know.
You just don't know.
No.
I'm assuming, James, you eat every day, correct?
Sometimes.
How much have you paid in food for all of 2024?
You get SNAP.
You never mentioned that. You're getting SNAP?
Yeah, I mentioned that in court. Last time I was in court, I mentioned that.
How much do you get in SNAP?
$191.
Okay. How much up and above the $191? Have you got, first of all, have you gotten $191 a month for all of 2024 from SNAP?
No.
When did you start it?
No, there's a month I didn't give my documentation in there, so I didn't get any money that month.
How many months in 2024 did you receive SNAP?
Missed 2 so far, so.
So you tell me 9 months. I mean, if I call the government,
Go ahead.
9 months, you got SNAP, 9 months in 2024.
Yeah.
Okay. When you did your financial ledger at the time of the divorce, what did you put down, James, as far as the cost of your food per month?
Now, this is my divorce or after that?
At the time of the divorce, without the children.
Without the children?
Pardon me?
You're confusing me, Sam.
James, come on. You have monthly expenses that far exceed the $8,000 that you're claiming that you made in the entire year.
Your Honor, I'm going to object. This is getting close to badgering the witness.
It is a bit argumentative. I'm going to sustain the objection.
You have gas, James, that you put in your motor vehicle?
I don't drive my vehicle, Sam.
So you have no motor vehicles that you've driven in all of 2024. You bought no gas in 2024 for your motor vehicles, even though you have a company, Redemption Construction, where you do construction. That's what you're claiming here today?
Used to do. Okay, Sam. I got evicted from my shop. Half of my equipment sitting over there in impound right now. I don't have a driver's license. That was suspended right before my busiest time of the year, where I make 3/4 of all the money I make. So that was taken.
I'm asking you how much money you spent in gas for transportation in 2024.
Yeah, I haven't really driven my truck very much.
You don't know?
Not offhand, no.
Okay. And so you expect this court to believe that just as soon as the divorce happened, you went from 103,000 net per year for 3 consecutive years. And in all of 2024, you've earned 8,000 net. That's what you expect this court to believe.
Oh.
Pardon me?
2020, okay, $106,000. And just so you know, that was when Kelsey was also with me. And then we were getting
James, I just want you to answer that question that I asked you.
which was what?
You expect the court to believe that you earned over $300,000 net income for 3 prior years, yet in all of 2024, your net income is $8,000, and you live in a house, and you pay water, sewer, garbage, heat, cable, electricity, vehicle insurance, gas, food, clothing,
And
and
object to the question as asked and answered.
Sustained.
so James, what jobs do you have going on right now?
I have a shop renovation.
Where's it at?
It's right over by MDI.
What's the name of the person who's paying you? Who did you contract with?
Chris L. He works for Trust out of Fargo.
What was the total gross amount of the contract?
$4,800.
What other jobs do you have going right now?
None.
Okay. And so if this court were to put you in jail today and give you work release so that you could go to that job, you could continue that job and finish it up, but yet be in jail and be released every day, correct?
So you're going to drive me?
You say you don't have a vehicle anyway, it was repossessed, and so you're getting there somehow, James, right?
Repossessed.
Where is your motor vehicle?
It's in my garage.
But you say you don't drive it anyway.
Yeah, I don't.
Okay, so how are you getting to your job if you don't drive your vehicle?
If someone
Objection
drives,
relevance.
I'm going to overrule the objection. I think the door has been opened to answer that question.
So how do you get to your job, James, if you're not driving your vehicle and it's sitting in your garage?
Tina drives me.
Who?
Tina. She takes me to work.
Who is Tina?
My girlfriend.
Okay, is she living with you?
No.
She's not living with you. Correct?
No, she doesn't live here, no.
Okay, she stays with you.
Every now and then, yeah.
Okay, where does she live?
Sioux Falls, South Dakota.
Well, how does she drive you to work every day if she's living in Sioux
Say I
Falls?
go to work every day, Sam. I just got this job.
All right, Mr. Hume, you need to take a breath and be a little bit less argumentative here, okay? Go ahead, Mr. Johnson.
So Tina could drive you to your job. If the judge incarcerated you today, Tina could drive you to your job as she's doing today, correct?
She didn't take me today, but yeah.
Pardon me?
She didn't take me today. And I don't think she'll take me anyways.
Oh, now she's not going to be able to take you, James? Remember, this was the excuse that you utilized, that you're not buying any gas for your motor vehicle to the very only job that you have. You understand?
Well, I could say I wasn't buying gas for my vehicle.
You're saying you didn't spend any money on gas for your vehicle.
Yeah, I
because
didn't spend any money on my. I never said that, Sam.
Yeah, you did.
I said,
how much
what
you
did I
spent.
say?
I asked you how much you spent on gas in 2024, your motor vehicle. You said, I don't drive my vehicle.
I said I
don't put any gas in.
and how much I spent on gas.
James, a reliable indicator of whether or not you want to pay your child support and you want to pay your obligations is whether or not you have done other.
I have made good faith efforts to comply with the support order and obligations, including communication with Kelsey about my financial situation.
So my question is,
financial circumstances have changed since the original support order. I've faced many different losses, reduced income, and difficulty, Sam.
Right, I understand that, James.
ability to abide by the court order.
You have not, according to the court order, you have not refinanced the very motor vehicle that the judge ordered you to refinance within a couple of weeks. And have you?
Where's my attorney at? Is this even?
Isn't that true, James?
What's true is what I said in court. Was that
James, it's a yes or no. It's a yes or no, James.
I can't refinance the vehicle.
Right. You haven't refinanced your household either, according to what you were supposed to do by this court's order. Isn't that true?
I couldn't do that, Sam.
Right. And your testimony, as I understand it today, you've paid zero on your household. You got to remember, James, this stuff is all discoverable. You're saying you paid zero on your household.
What I made last year, Sam, in 2023.
James,
Does that matter?
just listen to the question, James. You've paid zero household mortgages in all of 2024. You've paid zero in gas for your motor vehicle in all of 2024. And your vehicle is in your garage, you don't use it, this is your only job, but yet you've eaten all year, you got water, sewer, garbage, heat, cable, all available to you, your cell phone's all available to you right now.
Your Honor, is there a question somewhere?
Yeah, what's the question?
And you expect this court to believe, James, that you're not purposefully and intentionally just refusing to meet these financial obligations because that's what you told Kelsey.
What did I tell Kelsey?
That if she ever divorced you, you would make sure that you would never pay these obligations, anything that was ever ordered by this court, if it benefited Kelsey. Isn't that true?
Oh.
I have nothing further.
Mr. Barkus.
Thank you, Your Honor. James, why don't you have a license?
So it's revoked. It was taken from
Who took it?
child support.
When did they take it?
Like 20 days after the order came out
So what can you give me approximate?
in April.
In April? So you basically operated most of the year in a construction business without a license.
Yeah.
Do you have any employees?
No.
So you're the only employee?
Yeah.
And then you've received SNAP this year, correct?
Yes.
And is that the vast majority of what you use to buy food?
Correct.
And then you said that you've received assistance. Is that government assistance or private assistance?
I receive assistance to the IHEAP for to help offset the utility costs.
Okay. And what bills are you behind on for your house right now?
Behind on my mortgage, the utilities, the electric and Otter Tail, that's behind. The water's behind. The gas isn't because that got paid.
Is there anything else that you want the court to know about your situation for this hearing?
That's not the way Sam makes it seem. I'm trying. And I feel like I'm being shackled and just beat. That's not the same as it used to be.
I have nothing further, Your Honor.
Ms. Riddell, any follow-up?
No, Your Honor.
Mr. Johnson, any follow-up?
No, Your Honor.
All right, Ms. Riddell, any other witnesses, evidence, or testimony?
No.
Mr. Johnson, any witnesses, evidence, or testimony?
Yes, Your Honor. I'd like to call Kelsey Hume.
Ms. Hume, if you can please raise your right hand. Ma'am, for the testimony you're about to give, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
You can lower your hand. Please state and spell your full name for the record.
Kelsey Nash Hume, KelseyNashHume.
All right, Mr. Johnson, go ahead.
All right, I'm going to be very brief. Kelsey, you heard me ask James whether or not he ever told you anything in relation to how he was going to make your life if you divorced him. What specifically did James tell you?
I tried to leave before, and when it was a heated argument, he was screaming at me. I can't remember exactly the date, but said if I ever tried to leave again, he would make me pay for it and I would regret it.
Did he say anything about whether or not you were going to get anything?
Yeah, he said he would drive every company we had into the ground, so I didn't get a dime.
Have you seen James driving his motor vehicle in town?
I have.
Recently, over the last several months?
I have.
Okay. How does he get the children?
He drives to each exchange.
So he drives the very motor vehicle, which he claims he doesn't drive, which is parked in his house, to your location to pick up the kids?
Yes.
And does that happen like on Wednesdays and then every other weekend?
Yep. Yes.
In holidays and so forth?
Yes.
And you see him regularly driving around town?
Yes.
Okay. Is there anything else? First of all, he never did refinance the vehicle, correct?
No, he didn't.
What did he ever tell you about that motor vehicle? What he was going to do in relation to that motor vehicle, if anything?
No, I don't think he said anything specifically about that truck.
Anything about repossession or anything?
He told me that it was repossessed, that he doesn't own it anymore, that a company does.
But he didn't refinance it within a couple of weeks like the court ordered?
No, he didn't.
He never refinanced the household within 6 months like the court ordered?
No, he did not.
Hasn't paid his child support as court ordered?
No, he hasn't.
And for 3 months prior to that divorce, you and James were earning, James was earning through redemption over $100,000 net per year, correct?
Correct.
Was there any reason that you know of why it would have significantly decreased after you left him?
No, nothing other than what he said he would do.
All right. Is there anything else that, well, first and foremost, you're currently living in Wahpeton, correct?
Correct.
As a result of James' failure to make these payments, what's happening with you in relation to your housing?
I'm currently looking for a new house or apartment because with the money that I make from working at Walmart, I don't make enough to pay my rent. And I was really hoping that he would pay something on child support so I could get caught up, but I shouldn't have put all my faith into that. But yeah, I'm struggling.
And so what's happening at the end of the month?
I need to move out of my apartment.
You're getting evicted.
Yes, well, I don't want to say eviction because it might mess up my credit, but yes,
Okay. You've been asked to leave because
Yes.
you haven't paid your rent.
correct.
All right. Has this been devastating with respect to your financial obligations, including to your children?
Yes.
All right. I have nothing further, Judge.
Ms. Rydell, any questions for this witness?
No, Your Honor.
Mr. Barkas, any questions for this witness?
No, Your Honor.
Mr. Johnson, any other witnesses, evidence, or testimony?
No, Your Honor.
Mr. Barkas, any witnesses, evidence, or testimony?
No, Your Honor.
Ms. Rydell, any rebuttal witnesses, evidence, or testimony?
No, Your Honor.
All right. So, Ms. Rydell, your closing arguments and your ask for the court, please.
Thank you, Your Honor. The state would ask that Mr. Hume be found in contempt based on his testimony today. It appears that he does have his own business. It does not sound like it's been thriving, but he is physically able to work. Knowing that he has a suspended license or revoked license, he could take that to find a place of employment in town that he could physically walk to. There should be plenty of jobs for him to do so. As a person who is self-employed, he has the obligation to budget his income to meet his child support obligations. Child support should be a high priority, that he should be paying that. So the state would ask that he be sentenced to 10 days in jail with 10 days suspended. He can purge that jail sentence if he could make a $2,500 payment by November 30th, and then resume his monthly obligation of $2,041 beginning on December 1st.
Does the 241 include 20% for the arrears or the 2041?
I do not see a breakdown of what the percentage is. I just see that 2,041 is his monthly obligation. Interest varies. I suppose that depends on the principal balance, which is $48,677.05 as of November 1st.
All right, Mr. Johnson.
Thank you, Your Honor. Your Honor, you've been involved in this case for a very long time. Mr. Hume is just not going to abide by the orders of this court. He can claim everything that he wants. It's the economy and this and that. He just doesn't want to work, and this is all about revenge in his own mindset against Kelsey. He indicated he wouldn't, if she ever divorced him, this is what was going to happen, and this is exactly what's happening. Obviously, he's lying to the court, says he doesn't drive his motor vehicle yet, picks up his kids, you know, every Wednesday, every other weekend, all of this kind of stuff. I mean, he's driving around town. She sees him around town with his pickup. It's just not logical that you can stay in your house and then pay your water, you know, water, sewer, garbage, heat, electricity, cell phone, food, and all of that, and make $8,000 net for the entire year. It's clearly not logical. You know, it's no different than back in the day when they got Al Capone. And they figured out that, well, we can't get him on, you know, what he's doing, killing people and all of this, but so we'll get him on tax evasion because he's had houses everywhere and he had cars and this and that, and he wasn't claiming any income. Well, that's exactly what James is doing here. This is, you know, this is as simple as it gets. He's just refusing, just adamantly refusing to pay his child support obligation. You know, the motor vehicle he didn't do, the house he didn't do, you know, the foreclosed on it, and all of a sudden he tells me that, well, they just agreed to put everything at the end of the mortgage. Well, they don't do that unless you pay monthly your obligation after that. And he's saying, no, I haven't made any payments at all in 2011. It's ridiculous. His testimony is bizarre. It's, you know, his girlfriend, now she drives me to work, but she lives in Sioux Falls. You know, so he's just not going to get it unless he's incarcerated, period. So here's what I would suggest. We incarcerate him and we put him in jail for 30 days. But we give him the keys to the jail cell so he can get out every day and he can go to work. And his girlfriend can pick him up, like he says. And then he can get out as soon as he pays X dollars. The state has asked for like $2,500. You know, I think, you know, either not exactly sure how to do it, but he needs to start paying. And the only way he's going to pay it is if he's in jail, because he's not going to do it. I just don't, you know, and purging him of $2,500, you know, if you give him 10 days, he comes up with $2,500. Well, then he's good now for another couple months or 3 months or 4 months or whatever, until we do another order to show cause. He just doesn't want to pay. There's so many jobs in Wapaton, it's pathetic. I mean, Bobcat, Compdale, everywhere. There's just jobs everywhere, but he doesn't want to be, you know, imprisoned in a job. He wants to be able to do whatever he wants to do. So I would suggest we put him in jail. We just put him in jail. We leave him there and he gets out every day and he does his work and he makes his child support obligations on a monthly basis. Kelsey's getting, essentially, she won't have a housing. Literally in about 8 days, she's going to be out of housing. It's been awful for her to come up with enough money to feed the kids and clothe them and all kinds of school activities and lunches and things. So he needs to be punished. He did this in the divorce. And we know that when he refused to do so many things. I mean, clearly, obviously, at the time of the divorce, there was all kinds of indicativeness of that he was on methamphetamine. It's clearly he's probably still on it. And that's where he's spending his money. So in any event, that's what we would ask. Tailor something that's really going to punish him, but give him an out so that he can get to work, but he has to make those payments. Thanks, Judge.
Mr. Burkus.
Thank you, Your Honor. We would ask the court not to find Mr. Hume in contempt. He's testified to he's only had $3,200 in gross income in the last quarter. I think by any stretch of the imagination, that's not enough to provide for oneself, let alone pay a child support obligation that is just $1,000 more than that per month, and that's for over 3 months. Child support has already taken away his driver's license. Whether or not his ex-wife, who, quote unquote, got in a heated argument with him, is credible testimony on whether or not his driving is not really relevant for this, but it goes to the fact that people aren't going to hire somebody that for a construction job that doesn't have a driver's license. I think that is very logical in that regard. The other motion about changing, the obligations, aren't right for this hearing. I think Mr. Hume is doing everything that he sees that he can try to do. He's trying to better himself to becoming a home inspector. It's just not there yet. He's testified he's been on SNAP for most of the year, that he's behind on pretty much every payment that he has. And putting him in jail is only going to exacerbate the issue. So that's all I got, Your Honor.
All right. Ms. Rydell, any closing rebuttal?
No, Your Honor.
All right. So we start with the definition of contempt. That's what we're here for. Under North Dakota Century Code Section 2710-01.1, contempt of court means A, intentional misconduct in the presence of the court which interferes with the court proceeding or the administration of justice, which impairs the respect due the court. That does not apply here. B, intentional non-payment of a sum of money ordered by the court to be paid in a case when by law execution cannot be awarded for the collection of a sum. B, intentional disobedience, resistance, obstruction of the authority, process, or order of the court or other officer, including a referee or magistrate. D, intentional refusal of a witness to appear for examination, to be sworn, or to affirm or to testify after being ordered to do so by a court. E, intentional refusal to produce a record, document, or other object after being ordered to do so by the court. F, intentional behavior in derogation of any provision of a summons issued pursuant to Rule 8.4 of the North Dakota Rules of Court, or G, any other act or omission specified in the court rules or law as a ground for contempt of court. The court has options to decide whether or not to impose punitive sanctions or remedial sanctions for contempt, and that authority is derived under Section 2710-01.2. Remedial sanctions include a sanction that is conditioned upon performance or non-performance of an act required by a court order. A sanction requiring payment of a sum of money is remedial if the sanction is imposed to compensate a party or a complainant other than the court for loss or injury suffered as a result of the contempt. That's 2710-01.1, sub 4. Here the court finds the following. The obligor in this case, James Hume, appeared at the November 20, 2024 hearing on an order to show cause. The obligee, Kelsey Hume, appeared with her attorney. The obligor was present with his attorney. The state appeared through Jessica Rydell. In addition to any of the findings made by the court on the record, the court finds as follows. The obligor owes a duty of support, and he has failed to pay as ordered. That duty of support is statutory in nature. The obligor's last known address is 817 5th Street South in Wapaton, North Dakota, 58075. The obligor's employment history: he has worked as owner-operator of Redemption Road Construction, LLC. Currently, Mr. Hume's driver's license has been revoked by child support. Mr. Hume has the ability to work. Mr. Hume has willfully failed to pay child support as ordered by the court. Mr. Hume is approximately $48,000 in arrears. Before this court assumed responsibility and was assigned to this case, Judge Cruff entered an interim order on child support on November 30, 2022. In it, Judge Cruff ordered Mr. Hume to pay $1,572 per month, commencing on November 1, 2022, as child support. The court heard testimony at the trial that no interim child support had been paid. And at that time, Mr. Hume was approximately $20,000 in arrears when we had the trial. At trial, Mr. Hume and his attorney and Ms. Hume and her attorney and child support called witnesses relating to child support obligations. Documentation for Mr. Hume's income was received, including at least 3 years of child support, 3 years of tax returns, indicating a highly variable income for Redemption Road. I believe the first year of tax returns the court received indicated or reflected $106,000, give or take, for employment income for Mr. Hume. The second year was substantially less. I believe it was approximately $8,500. The third year, in 2022, Redemption Road showed income of approximately $188,000. And in averaging all of those across the 3-year window, child support came up with $103,000 income average for Mr. Hume. And that was the basis of setting child support in light of the offset after the court imputed income to Ms. Hume of $2,041 per month. The court heard testimony today. Although the ledger was shared on screen, it was not introduced as evidence, but the court heard testimony from Mr. Hume that he has approximately $48,000 in arrears currently. His last payment was in September of this month. And the last payment received in September by child support was $137.50. And that was received on September 3, 2024. The court believes Mr. Hume is intentionally underemployed. The court listened to the evidence and the testimony of Mr. Hume and Ms. Hume and finds Mr. Hume's explanation for non-payment to be less than credible. Does not make credibility findings with respect to Ms. Hume. Frankly, her testimony is irrelevant, other than to demonstrate to the court the impact that Mr. Hume's intentional noncompliance with the court order has on her and the children with whom she resides. The court's contempt order is as follows. I am going to impose remedial contempt punishments or remedial contempt orders. The obligor shall immediately report any change of address, employment, email, or phone number to the child support office and the clerk of court. All child support must be paid to the state disbursement unit. Self-employed obligors must budget income to meet their obligations. Child support is a statutory priority and must be paid before other debts. Parenting issues cannot be addressed in child support orders to show cause hearings. Court, as a remedial sanction, is going to order that Mr. Hume be incarcerated in the Richland County Correctional Center for a period of 60 days. Work release is authorized to the extent Richland County affords work release. Those 60 days in jail are going to be stayed for a period of 3 months. The obligor may purge the contempt and avoid incarceration by paying a minimum of $2,449.20 each month. I'm changing my mind here. So I'm going to stay that jail sentence for 6 months. Mr. Hume can purge the contempt and avoid incarceration by paying a minimum of $2,449.20 per month in child support for 6 months, starting in December of 2024. Court comes up with $2,449.20 by multiplying the monthly child support obligation contained in the amended judgment of $2,041 by 20%. Court adds the statutory 20% arrears. So when I add $2,041 to 20% of that amount for arrears, that equals 408.20. The court comes up with 2449.20. And so if Mr. Hume makes those timely payments in the amount the court has ordered, he can avoid going to jail. If Mr. Hume does not make timely payments, the court will issue a warrant of attachment and he will go to jail. Mr. Barkas, any questions about the court's order?
No, Your Honor, I think I understand it.
Ms. Rydell, any questions about the court's order?
Do you have that order drafted or do you want our office to draft it?
So I pulled up an order from the Child Support Enforcement Office, and that's what I was reading from. They have a stock order. I don't know if it's an odyssey or not, but I would ask that the state prepare that order consistent with the oral pronouncement.
Okay.
And Mr. Johnson, any questions about the court's order?
Yes, Your Honor. Just so that we are specific in nature on this, by what date of each month is he to pay the $24.49? Otherwise, a warrant of attachment will be issued by the court.
Ms. Shar told me not to put those dates in there, but she suggested that it's appropriate just to include the month. But the child support order that previously was issued in the judgment had the first of the month.
Okay.
That's when those obligations are due and interest accrues.
Okay.
So that was in the previous order, but for these contempt orders, Ms. Shar scolded me and said that child support doesn't like it when I put a specific date in it. So December 2024 is as specific as I'm going to get.
Okay, that's fair enough. And then If that payment is not made, is the state then to reach out to the court with another OSC, or does the court just issue the bench warrant? I'm not exactly sure how procedurally that works.
So procedurally, how that works is if child support indicates he has not paid, they simply send over a proposed warrant of attachment. And then once the clerks have it, they detail it to me. I sign the order, and then it's a do not pass go, do not collect $200, go straight to jail. There's no other hearing. The due process was afforded today. So it's not something for which it's bailable. It's not something that he gets another hearing later. That hearing happened today. So that's how that warrant of attachment process works. Simply put, if the non-payment happens, the contempt order operates by law automatically. I just have to sign the warrant of attachment, and then the sheriffs get that warrant and they come and collect Mr. Hume and bring him to the jail.
And that's for a period of time of 6 months then.
So the jail time is 60 days, all of which is stayed for 6 months.
Okay.
So if he makes timely payments for 6 months, no jail. If he makes untimely payments or payments not in that amount, the contempt order applies. He goes to jail for 60 days.
Okay, got it. Okay, sorry.
Make sense?
Yep, you got it. Thank you.
Anything else from any party?
No, Your Honor.
Could I get my license back? That way I can make this money, please.
I can't do that for you, but you can certainly get a hold of child support and tell them what I ordered. They will, when a payment plan is in place, sometimes release the driver's license, but that's a child support thing. That's not a court thing. Make sense?
Yeah.
All right. With that, we are adjourned. Have a good day.
Thank you.
Well, that looks like the end of the show, ladies and gentlemen. I don't know what to say. It's been 2 amazing hours of some really interesting court cases. I hope you all have enjoyed this trip around the judicial circuit from the past few weeks with me this weekend. My Lord. I think we found some winners. And welcome to the Bar Association, to our baby lawyer who got her wings early on in the show. That was really cool to see. If you missed it, Judge Simpson judiciated over a motion to bring a baby lawyer into the bar, and that was just amazing. So also rewind, watch. It's all fun. Ladies and gentlemen, I do these things every weekend at 11 a.m. Central Time, 12 p.m. Eastern Time. I also have lives every weeknight at 8 p.m. Central Time. That's 9 p.m. Eastern Time with the Fleischer Forum, where we basically just look over a truncated version of Fleischer's docket of the day and talk about what we see on the screen in front of us. We have a lot of repeat offenders that come through that court. We have a lot of interesting stories that happen right there, and it's always fun to do it with a guy who dresses so dapper. What can you say, right? Judge Fleischer is one of my favorites. So come by and hang out with me for the Fleischer Forum every night of the week. That's Monday through Friday, where we spend about 2 hours together looking over the court cases of the day with Judge Fleischer. And come back with me every weekend to look at some odds and ends of various cases that I find throughout the week that I just don't have time to make videos for. Hey, your comments may be included on a video in the future where I take these videos and snap them apart from the live stream and make individual standalone videos with them. That's what this does. It's also a time for us to get together and talk about the stuff together, learn something about each other, learn something about the cases, the law, while we're all learning about each other. Thank you all for coming out, hanging out with us. Love you, Mom. I'll see you later today, probably. Thank you, Dreams, for modding. Thank you to all my friends in the chat. You are all wonderful, and I hope to see you again next time. I am your Lone Wolf Usul. I'm the curator of the Court Gallery. I'm your host of this show, and I am out of here. Y'all have a great Saturday.